Hello, this is Kent. I am a former Wage and Hour Investigator for the U.S. Department of Labor, Wage and Hour Division. And once again, I am explaining my experiences with the Wage and Hour Division and with investigations. This is not, of course, legal advice. This is just my telling stories about how I felt when I went out and enforced the law and just general things which happened. Okay, so last time I gave kind of an overview of my experiences. Now I guess I'll get a little more into detail. Now, of course, somebody wonders what happens once a complaint is made. Once a complaint is made, usually by telephone, the complaint will be taken, entered in a computer. They'll ask basic questions such as obviously, where do you work, what's your name, all that sort of stuff. But what was the violation you allege? Were you paid less than minimum wage? Were you worked over 40 hours a week, didn't receive overtime, etc., etc.? So, after that, the Wage and Hour Investigator eventually receives a complaint. And when they do, they send a letter out to the business or whatever organization they'll be investigating. Could be a church or whatever. I will be meeting with you on such and such a day at such and such a time to discuss compliance with the Fair Labor Standards Act. I will be needing these documents, etc. Now, of course, you say, well, what is it really the Wage and Hour Investigator is after? Well, of course, they're trying to close their case as quickly as possible. Like anybody, you want to get through your assignment. But what they're really there for is to find a violation, close the case, assess a penalty, and get out of there. Now, this is all good and well for them, but it doesn't benefit a employer. So I always thought it was strange that employers allowed the investigator in. So at the initial appointment, I was like, we're going to meet at your business, we're going to discuss everything I need, and then I'm going to wander around your business, talk to your employees, make you look bad, and start asking questions that make them start wondering about you as their boss. I always wondered why an employer or organization would allow an investigator to do this. They really have no requirement to do it. I mean, you don't have to let the Wage and Hour Investigator onto your business or into your organization at all. So I was always like, do they think that the government has the right to just walk into a business and start poking around? Because they really don't. So I was really surprised that more businesses didn't just say, no, you're not coming into my business and making me look bad. You're not going to start talking to my employees during the time they're supposed to be doing work on my dime. And you're not going to come around here and start looking at what we do when really your sole purpose is just to assess a violation anyways. It's not like they're coming out as your friend. They're coming out hoping to find a violation and to make you pay. So I was really always kind of surprised people would even let you in. Now, the smartest employers I ever saw were the ones who would basically say, and it actually strangely didn't happen that often, but ones who would say, well, we're not meeting at my establishment, we're meeting elsewhere. That way the investigator couldn't just walk around and start talking to people. The mere fact that you have a government person at your business makes you look bad. People, even if you have no violation, people will start thinking, this guy's up to no good. So I would think that just as an image issue, I wouldn't want a government person there. And I certainly won't want them talking to my employees when I have no legal requirement to comply with that. Now, when you first meet with an investigator, you do basically have to supply certain information. Like I said, there was never a requirement that you let them in your business. It's nice for the investigator. I never thought it was nice for the business. And smart ones would always try to keep the investigator away, merely because I always thought you're making the business look bad, as I stated. But there are requirements that a business must give the government. Your basic sort of information, your tax ID and name of the business. You do have to keep certain records, but you don't necessarily even have to supply us all at the first meeting. The investigator wants it all at the first meeting, and it was great. So when I went out and I could send a letter and everybody give me exactly what I wanted, I could be in and out of there in 4 or 5 hours, maybe spend a day at the business, come back a week later, have all the violations assessed. That was wonderful. Time was my enemy. The longer that case went on, the worse it was for me. Better it was for the employer, but worse it was for me. So I always loved it when people are real willing to comply and really very helpful. Not because I was going to be helpful to them. I certainly wasn't. That wasn't my role. It wasn't the purpose of it. The irony I always thought is the people who were most punished by the wage and hour laws were the people who were most looking to do the right thing. Ironically, it wasn't the businesses who were trying to screw over their employees or really trying to do the wrong thing. It was the ones who tried to do the right thing. The ones who knew they were doing wrong, they were much harder to deal with. So in the end, if you had two businesses that were essentially the same, and one knew they were not in compliance and they weren't cooperative, they were much more likely to get away with violations than one who was cooperative. So I guess the good guys being punished and the bad guys just basically, thumbing his nose at the government and walking away. And I thought that was that was kind of sad, but that was reality. Now, time, of course, was always my enemy as a wage and hour investigator. And the real reason is because there are statute of limitations. Basically, you're looking back 2 years to look for compliance. So the longer this case went on, the more back wages were eroded, and also the less chances anything could go to court. I mean, not that it's likely it ever go to court anyways, but the chances something might were being diminished every day. So as an investigator, I would go in and I'd hope to quickly assess. And like I said, if somebody was real cooperative, it'd be perfect. I could go in, they give me everything I need, let me wander around their business, start talking to people, probably make them look bad in the process, and then assess back wages, give them the pay, and walk out. Okay, so of course, the reason time was so important was because of the statute of limitations. When an investigator goes out, he or she is looking at a 2-year period of time, retroactively, of course, and they're looking for compliance during that period of time. So, the smartest thing an employer ever did would just say, okay, well, they'd really question the investigator, saying, what do I need to do to comply? And this is before the investigation even started, really before they even started asking questions about the business or started trying to interview or look at records, saying, what is it specifically that you want from this business? And then just tell them that you're in compliance. Because at that point, if you can say there's no violations going forward, Now you're running the clock on the investigator. And that's really what the investigator did not want. Time was the investigator's enemy, and that was always my enemy. The thing I wanted was for somebody to just let me go in, do what I wanted, give me all records, so I could walk out, assess some violations real quickly, and come back with penalties, or not penalties, but back wages, and give them the pay and be done. Now, I think a lot of people would be of the opinion that I want the government to be done quickly and just get them out of my hair. And I always thought, why would you want that? It really is no impediment to you that the government is looking at you. And the longer the government looks at you, the worse it is for the government. They're just like any other organization. They want to get through things quickly and efficiently to be productive. And the longer it is for them, the worse it is for them. So I was always surprised. People would be like, look, just get through it quickly. Here's everything. Go away. I would say, sure, you can keep doing your investigation and expand it out time-wise. But you're not doing it on my time. You're not doing it on my property. What the investigator needed, of course, was to speak with employees and, of course, to get records. Those two things were really everything. I mean, it was really the majority of what they're looking for. Everything else is just some details around the case. But you need employee statements, and you needed records. So, of course, if you had great records, you could probably assess a violation with only speaking to even a couple people, because it's all on the record. But employee statements are essential for any sort of legal case against a business, which is why I was always surprised people would let you speak to the employees. You don't have to let them speak to your employees, of course. So why are you going to let them literally get witness statements, which is what employee interviews are? They're witness statements. It's like a cop going out to a crime scene. Like I said, it's not a crime. It's a civil law. However, this is literally the exact same thing. You don't have any requirement to let them poke around your business, so why are you going to let them sit there and take statements that could potentially be damning for you? So when I was an investigator, and I would go out and I would deal with businesses such as construction and landscaping, businesses which dealt with a lot of undocumented labor, a lot of these people wouldn't want to speak on site because they were afraid they were going to be terminated. They would be fired if the boss saw them speaking to anybody. And of course, that's would be very easy to do for an undocumented individual, and especially in a right-to-work state. So they had good reason to be concerned. So if you're going to really communicate with these people, you had to do it off-site. Now, the biggest problem with that is, how are you going to find them? So I would always be looking for phone numbers. Now, the employer doesn't have to give you phone numbers. There's no requirement they give you phone numbers. But the investigator's always asking for phone numbers, because how else are you going to get hold of these people? Are you going to send them a letter? I mean, no one's going to respond to a letter. At least no individual which is going to respond to a letter if it says, I'm coming to your house to speak to you about your employment. Plus, if it's undocumented individuals, they're going to be hard to find at their home anyways. So if you have no phone numbers, it's next to impossible to find these people. You'd be knocking on doors. So I always thought it was funny that employers would be so willing to give information that made your job easier. Because as I've said before, the longer this goes on, the worse it is for the employer. There's a point in time at which the case has been going on so long that there's zero chance it would even be possible to litigate. I mean, I think probably by a year in, there's a 2-year statute of limitations, but by a year in, case is dead. Unless you're a repeat offender who the Wage and Hour Division's been out to several times after a year of investigation, I mean, it's pretty much dead and gone. There's not really much they can do. I mean, they can still go to you and try to assess, but what are they going to do? So what I'd say in regards to the time frame is, the employer's not in your hair. The investigator's not in your hair while they're investigating. I mean, it's not like they're hanging around your business, coming to you every day. You're seeing them once every couple months, by the phone most of the time. They show up at the initial meeting. There's really only 2 or 3 meetings they even have with you. They show up at the initial meeting. They want to come to your business, which you can just say, no, you can't come to my business. And then, of course, they're going to have a final meeting with you where they assess the violations, or at least say there's no violations, but here's what you have to do to comply, blah, blah, blah. Just give some information. And there could be multiple meetings if you're negotiating with the investigator. Well, like I said, as it drags on, the back wages erode because this is a statute of limitations thing. And since, of course, the longer it goes on, if the investigator ultimately says, okay, they're not in compliance and they're not cooperating, I'm going to try to send this up the chain to my supervisor and maybe eventually the solicitor's office, that's going to take months. If I was ever to send a case to my supervisor, they might take a year to look at it. They'll probably take months. They might take, unless they're really hot to get on this case, they'll probably take 3 months, maybe 3 to 6 months to even look at the case. So I'll sit on the corner of their desk for 3 to 6 months, kill them back wages. And part of the reason the supervisor does that is because it's a negotiating point for them. They're not telling you that, but if back wages have eroded, they can start negotiating those back wages away. And you say, well, we've assessed, let's say $100,000. It's easy. $100,000, but we can settle for $50,000. Well, they can sell for $50,000 because it's all eroded anyways. It's all gone. Statute of limitations have run on that $50,000. That's why they're so willing to give it away. So a lot of times they'll leave it on their desk so that they can negotiate it away, and no one's going to ask them questions as to why did you give $50,000 away. Well, because it was gone already, and it's the investigator's fault. I'm going to blame that guy. Well, had he done his job, I wouldn't have had to give that money away. Next, of course, if the supervisor couldn't get this thing resolved, they, in theory, could send it up the chain to the solicitor's office. Now, it's not very likely that they would do that. Most cases, they never refer to a solicitor's office. But if they did, they'd still want to do it in a timely fashion. It's the sort of thing where you want to send that to a solicitor's office in the first couple months, not after a year, because then it's going to take the solicitor 3 to 6 months to even look at it. And they might send it back to you saying, we need more of this or that. And by the time an investigation's done, so much of the statute of limitations have run, it's dead. It's almost irrelevant. They could try to start a new investigation, potentially. But more than likely, they just want to rid their hands of it, wash their hands of it. Frequently, you would get committed employees who really did want to communicate with you, especially if they're American. Undocumented is another story altogether. But if they're American and they want to communicate with you, they'll come with record in hand and with statements. And if you get a decent number together. Say you have 8 to 10 of these guys together. You could easily assess violations pretty quickly, because they would meet with you off-site, or they'll give you their phone numbers. One guy will give you 5 other people's phone numbers. You can call them, and they'll discuss it with you. So you know what's going on, and they, of course, will have their own payroll and or their W-2s or whatever, and they can give it to you. So even if the business is thumbing their nose at you, you'll still be able to get that information together. Be a little longer, a little harder, but you can still do it. So I was still capable of doing that. However, you'd still have to meet with the employer and then discuss violations with them. When I met with employers, they were always wisest if they were standoffish. They would let me say my part. They'd say, okay, tell me what you have, tell me what your issue is. And I'd say, well, I found these violations. And then they'd say, well, okay, I need time to review this and think about it myself. See if your allegations are true. Because just because I said it's true doesn't mean it is. I'm just the investigator. It's like I said, just because a cop gives you a traffic ticket doesn't mean that a court's going to uphold it. I mean, like I said, this is not a criminal law, this is civil law. And that's a completely different scenario, because you're not getting a ticket on the side of the road, obviously. But it's something that you'd still have to prove in court. So the allegation against you, you have a chance to review. And as an employer, I would have said, yeah, I'm going to take a look at this allegation. I got to look at this and determine if what you say is correct. And then I just say, okay, I'll meet with you, and after I review this, give me a month. Give me a couple months. And then after a couple months, I get back to them and say, well, I disagree, and I don't think that's correct. Or even then, if I said that, even if I said, well, it looks like there might be a violation, let me now take more time to see if I can get some computations together. And this was frequently how people would run the clock on you. They would always ask for more time. They'd be like, oh, okay, you're right. Let me see how this goes. Or not even you're right. Just let me take a look at this. Let me crunch some numbers. And then when they get back to you, they say, oh, I got really busy. Didn't get around to crunching those numbers. Sorry. Give me a little more time. And they know what they're doing. They're intentionally trying to run the clock on you. Actually, that's really what lawyers did. A lawyer isn't looking to go to court. They're not looking to have a legal argument with you. If you ever deal with a lawyer as a wage and hour investigator, and they're not looking to close a case and get back wages paid themselves, they're just going to run the clock on you. I mean, that's 99% of what a lawyer does is run the clock, at least in wage and hour. So I would always have employers come out and say, or at least wise employers, should I say, come out and say, I need more time to review this. I need more time to compare what you say to my records. Another issue I had was the individuals who realized that they weren't signing anything. They shouldn't sign anything. That also was wise, because once you sign anything, you're agreeing to something with the government. So once again, if some government investigator showed up and shoved some piece of paper under my nose and said, sign this, I'd never do it. I was always surprised people would. It's not like they can say, if you don't sign this, you go into jail. It's not like a traffic cop which says, sign this ticket, or you go in the back of my squad car. But what you'd always have an investigator looking to do is to get the company to sign a piece of paper, because that piece of paper was legal evidence against the company. Is either an agreement, which now they go back and say, look, you signed an agreement. You said you understood you had a violation and you're going to take care of it, and you haven't. And they can use it against you. Now, the worst thing the investigator could do, however, was to leave you documentation that you didn't sign. So if the Wage and Hour Investigator came up and said, okay, I've assessed back wages of $25,000. Here's my records of the $25,000. Here's my calculations of the $25,000. They actually wouldn't want to leave that with you, because then you can go back to them later and say, hey, this is what you said was my violation on my back wages owed, and this is what you have to stick to. If the government wants to kind of threaten you, they'll come up and say, well, we're going to up the back wages, assuming you haven't complied within the last 6 months or last year. They'll basically be their threat. But you'll be like, no, you gave me this documentation saying it was $25,000, so it's $25,000. And oh, by the way, half that's eroded. And I disagree. Anyways, but I would never sign anything the government gave me in that regard. Like I said, they're looking to find some sort of way to punish you. So realizing anything they're trying to do with you is not good for you. A lot of businesses would use lawyers, and I always thought, well, that was an expensive way to deal with the wage and hour division. I mean, you think a lawyer could be as much as the back wages are. But I actually was glad there was a lawyer usually. First, there'd be no emotional involvement with the employer, who's, of course, mad and upset that you're out of their business. But many times the lawyers wanted to deal with you, because that's how they got paid. They wanted to deal with you, and they wanted to agree to violations. And the reason they want to agree to violations is to give themselves purpose. If they say, well, you did something wrong, but I was able to negotiate this down to 25%, 10% of the back wages due, look how much money I saved you. You could still come to some sort of agreement eventually. Hopefully it'd be more than 10 or 25%, but the lawyer would hopefully be a source of negotiation for you. So I was always happy to deal with lawyers, and I'm glad when I heard the business had a lawyer. I was like, oh, thank God, at least there's somebody I can deal with who will, work with me, cooperate with me in some sense, or somebody I can argue with. And like I said, I don't care if they're billing the employer. That's the employer's problem, not mine. I'll call this guy frequently or try and meet with him frequently. It makes no difference to me. And he gets to bill his his customer for that. In-house lawyers are different, though, because in-house lawyers don't have the same need to negotiate that a third-party lawyer does. If this is a lawyer the business always uses, has basically a standing contract with the company, or is just an in-house lawyer who works with the business every day, on whatever, they're up on their third floor or wherever they are, it doesn't behoove them to negotiate. It doesn't behoove them to get the case done quickly, because they're not charging any more for it. They make the same money regardless. So those ones were harder to deal with, I found, because they didn't get anything out of a negotiation, and they knew they just wanted you to go away. And a savvy lawyer would know, once again, that they're trying to run the clock on you. One of the things about a lot of lawyers, though, is most lawyers don't know labor law. Very few lawyers know labor law, and I always found that they didn't take too much time to figure it out. Of course, one of the biggest tricks of all lawyers is to just sit on something and let time erode, whether it's Wage and Hour or something else. So a lot of lawyers would go in and they'd try to negotiate with you without even looking at the law or knowing the law. And that was both a double-edged sword, because you would then kind of have to educate the lawyer himself or herself. Have to educate the lawyer about the law, and the points they're trying to negotiate with you are not relevant. They try to say, well, we gave them this benefit, and you go, well, that's not relevant. That doesn't counteract this. In the end, the worst lawyers are the worst lawyers for me to deal with. I shouldn't say the worst lawyers. I guess it's all your own perspective. But worst lawyers for me to deal with were the ones who knew that you were a paper tiger. And they knew if this doesn't go to court, who cares? An allegation's just an allegation. It's kind of like a cop says, tell it to the judge. Well, if there's no judge, who are you going to tell it to? If the employer hasn't signed anything or agreed to anything, what does it really matter? You have the opinion of an investigator, the allegations of an investigator, but you don't have anything really all that damning, because it's never been proven in any sense. I mean, real sense. It's never been proven before a judge or before an administrative law judge. There's been no body of individuals to review this and say, well, you did wrong. So the worst lawyers were the ones who understood that without going to court, or really played off the fact that if it didn't go to court, it was irrelevant.